A very good evening to all viewers. I, Tejnani, a research assistant of the Student Division of Legal Desire, would like to get into the intricate details as to how the various methods of alternative dispute resolution can be used as a means to deal with corporate or personal insolvency resolution process under the necessary provisions of the Insolvency and Bankruptcy Act 2016. Now, one could say that the Insolvency and Bankruptcy Code 2016 has proven to be an efficient code enacted by the legislature in order to help the creditors recover their debts from companies which are on the brink of insolvency or bankruptcy. According to a Reserve Bank of India report, the rate of debt recovery has increased by 42% as compared to the 8 to 10% which was the scenario when the earlier regimes were in place. There were a number of laws dealing with these processes, such as the Sikh Industrial Companies Act 1985, the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, the Recovery of Debt Due to Banks and Financial Institutions Act 1993, and lastly the Companies Act 2013. The provisions of all these acts, along with the previous regime, caused a severe hindrance in the entire debt restructuring process, and this led to the collapse of multiple organizations and along with them the collapse of their investors and their creditors as the non-performing assets of the corporation went on accumulating. However, there was no proper regime in place to settle the debts by way of selling these assets, and this resulted in the creditors simply waiting for years to recover their money. The development of the code brought about serious changes to the erstwhile bankruptcy regime in India, as a time-bound resolution process was incorporated under the provisions of this code, which in turn led to a straight reduction in the time frame which the parties usually spent when the matter went on before the court. A number of well-known institutions like the IBBI or the Insolvency and Bankruptcy Board of India, insolvency professionals and information utilities were established and set up in the official capacity as a regulatory authority under the necessary provisions of the code. Now, one of the other important aims behind the enactment of this code was to ensure that all the broken pieces of laws pertaining to insolvency fall under the garb of one single code which deals with all these broken pieces together and in their entirety. The purpose of combining all these laws pertaining to insolvency is to resolve the uncertainty and the ambiguity which tends to arise from the application of a number of laws administered and enacted by various authorities, thereby leading to procedural delays and also leading to a decrease in the value of the assets. Now, ideally, according to the provisions of the code, the total time a corporate insolvency resolution should take from its initiation to its conclusion, taking into consideration the extensions which are guaranteed, is a total of 270 days. However, at times these matters go on for a very long period of time and exceed the 270 days mark. The National Company Law Tribunal is the desired tribunal which deals with the matters relating to the corporate insolvency resolution process, and NCLT is burdened with a lot of cases despite having a number of branches. In the current pandemic situation, due to loss of business, a lot of companies have come on the brink of insolvency and have filed for insolvency, thereby increasing the load upon the NCLT. The time which is consumed by the NCLT to liquidate a company and then adopt a resolution plan will only tend to increase if it does not approach the backlog of the cases and deals with cases with the help of a problem solution approach. Under such a scenario, it is imperative for the courts to refer matters to insolvency, to mediation or arbitration. Some debtors may in fact be too cautious to approach the court due to issues such as the goodwill and the sales getting hampered if the news comes out that a particular company is going insolvent, and the fear of dealing with the companies who may enter the moratorium at any time. Therefore, if matters of insolvency are referred to mediation or arbitration, then under such circumstances the matters would be dealt with utmost privacy, and the debtors and creditors could sit down and understand what each party wants with the help of the mediator or the arbitrator. A lot of parties currently prefer filing the insolvency proceedings before a court. However, due to the backlog that the NCLT is already facing, there could be a chance that the value of the non-performing assets of the debtor could fall significantly, and then the debtor would have to make a distressed sale in order to pay off its debtors. Instead, if the parties chose to settle the insolvency proceedings outside the four confines of the courtroom, then it would help them reach a peaceful settlement along with the reconciling the principal interests of the insolvency cases. The matters would be dealt with utmost secrecy. not leading to a drastic fall in the value of the assets of the company. It is beneficial to choose ADR over taking the matter before the tribunal or the court, as the debtors and the creditors could get along with the mediator or the arbitrator and come up with a debt restructuring regime. The debtor could renegotiate the debt repayment regime with the creditors. However, unlike an insolvency proceeding, this could be deemed to be regarded as an informal negotiation which would certainly not consider the aspects of all the creditors, and this could perhaps be undertaken while the company is still solvent and still has the necessary working capital to carry on its business. Further, this technique is said to be initiated before the company or the organization turns insolvent. Now, a question would arise with regards to what other remedy is available under such circumstances. Well, the parties could resort to a pre-insolvency proceeding. This includes adherence to the various processes of ADR as a method of tackling with the proceedings which could otherwise be deemed to be normal judicial proceedings. These can be divided into two parts. These categories are unrelated, however they can be very effective. The parties could work out a supporting proceeding. This means they could commence such a proceeding when the company is actually on the verge of a financial saturation, which simply means that it does not have the necessary means to carry out its business activities on a day-to-day basis. The procedure may not include all the creditors of the company and may solely include the financial creditors of the company. In a number of foreign countries, such proceedings are carried out in the presence of a mediator who is appointed by the law court. The involvement of a law court is strictly limited to the appointment of a mediator, and it ends there. Section 89 of the Civil Procedure Code 1908 provides that mediation can be used as an alternative method of dispute resolution. However, there are no explicit provisions under the CPC which state that it can be applied for insolvency resolution. However, the main goal in an insolvency resolution process is to resolve the matter privately and to perhaps tackle the issue before the company actually reaches the advanced stage of insolvency. Further, it could go ahead and carry out a restructuring process when one thing is sure, that the debtor is bankrupt and the insolvency proceedings are ought to follow. This can be commenced after the company has been deemed to be declared as insolvent. However, usually companies go ahead and file the insolvency process before the NCLT. The process could comprise of various ADR processes, usually conciliation and mediation between the debtor and his creditors. However, as stated before, in a pre-insolvency proceeding, the law courts usually just appoint a mediator and then they do not interfere in the proceedings. However, while carrying out the proceedings, the involvement of the law courts can be much more. So this just shows how crucial it is for companies to resort to ADR instead of opting the traditional means of resolving their insolvency proceedings. Insolvency disputes can be very well resolved without the issues that may arise if the said dispute goes to court. In fact, Honorable Mr. Justice Sikri propounded that it is crucial that mediation be incorporated as a means of dealing with the corporate insolvency resolution process in his article titled Mediation in Corporate Insolvency, a Game Changer. In his article, Justice Sikri also reiterated that the desired time, as per provided under the IBC 2016, to commence and resolve a CIRP, including the time taken for extension, is 270 days. However, seldom does the matter get over within a time frame of 270 days, and in fact it goes on for 365 days or perhaps even more due to the backlog that the NCLT is dealing with. Now, one question that would arise to you is whether it can be deemed to be regarded as a successful method and whether it has been accepted internationally. Yes, as a matter of fact, what Honorable Justice A.K. Sikri said, I totally believe that matters of insolvency should be referred to mediation and to other sources of ADR, and this totally makes sense, as if the matter is referred to NCLT, then with a humongous backlog, the total value of the non-performing assets of the debtors would also fall tremendously, and also it could lead to tarnishing the image of the company. This is why the courts need to encourage the parties to an insolvency proceeding to refer the matters to mediation or arbitration. Now, whether it has been accepted internationally, I would like to state that Singapore has stated that it is crucial to adhere to mediation in an insolvency resolution proceeding, as it would lead to the development of an international insolvency resolution sector. A committee was also set up to deal with these aspects, and the judges of the Singapore courts reiterated that it is essential to recommend parties to follow ADR as a means of resolving their disputes, specifically insolvency resolution processes. The Hong Kong Arbitration Center (HKIAC) in 2008 itself propounded the establishment of a mediation scheme while dealing with the insolvency proceedings. The scheme also delved into how arbitration could be the other means of ADR which could be referred to while dealing with insolvency proceedings in cases where mediation failed. This scheme propounded by the HKAIC can be deemed to be regarded as the med-arb scheme. HKIAC also contended by 2009, 85% of the cases were proceeded to mediation and it saw a 100% success rate. In the United States of America, mediation was used as a method of ADR when the Greyhound Lines Inc. fell under the clutches of bankruptcy. A pre-reorganization mediation plan taking into its ambit innumerable claims against Greyhound Lines Inc., which were in consonance with the accidents or the road mishaps. In this case, a number of parties were claimants with regards to the damages caused by the various accidents which were caused by Greyhound's vehicles, and the mediator sat down with each creditor individually. Besides, in France, the insolvency resolution model, when referred to ADR, has been highly successful. The regime which is laid down by the French consists of two stages which can be deemed to be regarded as those stages which prevent a company from going insolvent. However, the US bankruptcy law, on the other hand, refers to ADR during or after the insolvency proceeding has been initiated by the debtors and the creditors. Now, coming back to the French regime, the three stages are court-assisted pre-insolvency resolution proceedings, court-directed pre-insolvency resolution proceedings, and formal judicial proceedings. The first two, as I already stated, are those steps which could prevent the company from going insolvent, and these include mediation, negotiation, and conciliation. The first step can be deemed to be regarded as quite an informal proceeding with limited court interference, and this maintains the confidentiality of the matter. However, the second step involves much more interference from the court, and if this step is adhered to, then the confidentiality of the matter is lost. The first and the foremost goal and motive of these processes is to save the business and pull it out of the clutches of insolvency, which it is falling into. This just shows that other countries around the globe have successfully resolved insolvency resolution processes by referring the disputes to the various methods of ADR. Now, another question which may pop up into your head is whether there's a way forward in India. Yes, but India is still in its nascent stages when it comes to dealing with insolvency resolution processes, considering the fact that insolvency code was just enacted 4 years ago. However, with the improvement in laws and regulations, it surely is going to be the next big thing. It is imperative for laymen and people to get a hang of these laws and understand them in a simplified manner. Finding out the intricate details in the law is the job of the lawyer. However, it is imperative for laymen or businessmen to also understand how crucial it is for a company to understand the scope and the ambit of insolvency and bankruptcy laws and how they can be resolved through ADR. Insolvency occurs when an individual or a group of individuals operating a business together, sharing the same interests, are unable to pay their debts. In such a case, the company or the various partners of the company are deemed to be regarded as insolvent. It could be regarded as a process wherein the creditors, the government, and the prospective investors come together and work in consonance to help the company, which is on the brink of insolvency, to revive. Now, after the company has been salvaged by the parties mentioned above, a company can function normally and be free of its inability to repay its debts, and these parties, instead of going before the court, could opt for resolving insolvency matters themselves with the help of ADR. For instance, since 2016, many companies which were on the verge of insolvency got revived. Bhushan Steel, for which Tata bid, Alok Industries, for which Reliance bid, and similarly Ruchi Soya, which was acquired by Patanjali, got revived. Alok Industries, under the banner of Reliance, started preparing PPE kits in light of the ongoing COVID-19 pandemic, and this led to the development of a 10,000 crore business. In 2019, Alok Industries shares were available at a meager price of Rs 5. However, at present, the share prices of Alok Industries have soared up to 55. Similarly, Ruchi Soya, which was available at a share price of rupees 1.7, is now available at a share price of 1,500 per share. So companies under insolvency can be revived and in fact could be regarded as the game changers in the recent times. I would further like to state that the idea of referring the matter to insolvency to ADR is relatively new and India is in fact proceeding towards it. A report by the Insolvency Law Committee, which was launched in March 2020, elucidates on the fact that the code is about to bring changes and develop ways which would help debtors make an efficient use of mechanisms such as debt settlement, mediation, and debt counseling. It was elucidated that the debtors need to make a constant effort with regards to the various options which are available to them when it comes to solving matters relating to insolvency and understanding these confusing aspects in debt. The need for incorporating means or ways of dealing with matters outside the court has been developed. However, there have been no efforts made till date to formalizing or accepting them as a valid means of dealing with insolvency process. Such a system may take ample of time in India to set up as India is in its nascent stages. However, in a country like India, wherein a number of companies are filing for insolvency and bankruptcy, such a method, if introduced and accepted, would lower the burden which has been imposed upon the NCLT and help the parties to proceedings deal with these intricate matters with utmost privacy. Finally, as I sum up, all that I would like to say is that there have been innumerable instances wherein the application or wherein the reference of a dispute to ADR has helped the parties to resolve their matters quickly and easily. However, it is imperative to understand that referring to matter to ADR allows parties to come up with new, innovative solutions, and there's also a chance that the resolution or the conclusion at which the parties arrive could be deemed to be regarded as financially beneficial for the financial as well as operational creditors. Instead of relying upon the court to draw up or come with a sugar-coated resolution plan which does not delay the entire process, leading to a fall in the value of the non-performing assets. And with this, I would like to conclude my talk for today. Thank you everyone for listening to me. Have a nice day. Thank you.